Hello to everyone. I am Denard, an associate professor, and this is the second video regarding sharing knowledge on the EU. And this video is part of the Shalmonet project that I have won. So in this video, I will focus in two main concepts, which is sovereignty and federalism. And then I'm going to explain the EU law. In the first video, I stated that it is really important that states have given sovereignty to international organization or to EU institution. As I said in the first video, EU is a sui generis organization, which is based on the fact that countries have decided to give their sovereignty to this institution. In addition, also in the first video, I mentioned that there are several similarities between the EU and national state. In this video, I'm going to go in more deep in regarding these two concepts that I have stated before. So sovereignty, there are different types of sovereignty, such as royal sovereignty, national state, or parliamentary sovereignty. Sovereignty, first of all, it means self-determination. From an external point of view, is used in the public international law, and it comes as a result of the Peace of Westphalia, which means that the country has its own independence from the other country, and it does decide according to what is best for its country. Internal sovereignty means the popular will. So basically what the people have given to the parliament. Within the internal sovereignty, there are several concepts such as popular sovereignty or royal sovereignty. Royal sovereignty means that the king or divine law is limited by the constitution. Popular sovereignty means that the people, the persons are given the sovereignty to the parliament to rule. So it is really important to distinguish between popular sovereignty and national sovereignty, because popular sovereignty, the referendum is legally binding, rather than in the national sovereignty, as it was the case of the Netherlands during the referendum of the European Constitution, the project of peace of 2003, which was not approved. In the case of national sovereignty, which is an abstract notion, it means that the citizens that are today, the citizens that used to live, and the citizens that will live. This means that the constitutional referendum are not legally binding. In France, there is a mix between popular sovereignty and national sovereignty, because national sovereignty belongs to people who exercise it through their representative, means popular sovereignty, or by the means of a referendum. So, in addition to this concept, there is also the concept of state sovereignty, which means that one country is independent from the other, and the international organization can interfere in that country only if they have ratified it or if there is a violation of the EU's content. What about the EU? The EU, as I stated in the first video, is based on the principle of subsidiarity, which means that the EU may only intervene in case that the EU intervention is more effective than the national local levels. So, regarding the second part of this video, which is the federalism. The federalism means that a country is divided in subunits, and these subunits have also legislative power. It is really important, as we are going to see later, that there is a difference between federalism and decentralization. Decentralization means that the subunits have only administrative powers. This picture, which has been taken from a source in Wikipedia, shows how many countries have a federal system and how many countries have not a federal system. The main characteristic of a federalism is that there are subunits. The subunit may be called states, such as the case in the US, provinces, such as in the case in Canada, Länder, as in the case of Germany, Austria, cantons, as in the case of Switzerland, or regions, as in the case of Belgium. There are several advantages and disadvantages of the federal system that are written here. So, the characteristics of the federalism is that there is a division of the territory in smaller subunits. This is also the case of the EU, which is divided in different nations that are the 27 nations that are full members of the EU. There is a regional autonomy, which have their own constitution and federal power. This is also the case of the EU, that each nation has their basic law or constitution, and they have also their laws and bylaws. In the case of federalism, it is really important that there is a supremacy of the federal law or the federal constitution compared to the subunit law or subunit constitution. And this is also the case of the EU, as we are going to see later with the decision coming from the European Court of Justice in 1963 and in 1964, which states not only supremacy of the EU law, but also primacy and direct effectiveness of the EU law. Again, federalism, there is a regional representative in the main unit, and this is also in the case of the EU. For instance, in the case of the ordinary legislative procedure, the right to initiate is the European Commission that submits the proposal to the Council, which is the voice of the EU member governments, and also to the European Parliament, which is the voice of the EU citizens. And obviously, there is also a codification of the prerogatives. And this is also the case of the EU, that the prerogatives are written in the TEU and the TFEU, and they are governed according to the subsidiary principles. Again, there is a participation in the constitutional amendments. This is also the case of the EU. For instance, as I stated in the first video, the case how to make a modification by entering a new member state. And also there is the Constitutional Court, which aims to interpret the national law and to also ensure the division of power between the central institution and the others. Also, this is the case of the European Court of Justice that has as an obligation the interpretation of the EU law coherent with the TFEU and TEU, and ensuring countries and EU institutions that are binding by the EU law. As I stated in the beginning of this video, there is a difference between decentralization and federalism. In the case of decentralization, there is no autonomous legislative or governmental power. In the EU, there is a difference between confederation and federation. That confederation is typical of Council of Europe or OECD, and there is a cooperation. The goal is not to make a new single state. In the case of federation, it is really similar in case of the EU. The goal is the integration, and the similarity with the EU are extremely high. However, there is no national sovereignty. In the EU, in addition to the power given to the EU as an institution, there is also a possibility on enhanced cooperation. At least 9 EU member states in a subject that EU is competent, but the Council have stated that in the near future it is not possible to have an EU law. There is a possibility of open doors, so other EU member states can join, and the costs and obligations coming from this enhanced cooperation within EU member states is divided only from the countries that are part of it. This is so rare, and here we have two different examples: is the law for divorce or the parent protection. Now, the third part of the video deals with the basic concepts of the EU law. EU aims an internal market without borders. There are the four fundamental freedoms: good, persons, services, and capitals. There are the primary sources, which are the treaties, and there are secondary sources, as stated in the first video, and the legally binding sources are regulation, directive, decision. And as I stated in the first video, there is some importance of the soft law, because these soft law are becoming in the future secondary sources. The European Court of Justice has a really important role in the case of enhancement of the EU law, because in 1963 it stated the supremacy of the EU law. In 1964, it stated that EU member states have limited their sovereignty and people can directly use the EU law in the national courts. As I stated, the main secondary sources of the EU law are regulation, directive, decision, recommendations, and opinions. The last two are not legally binding. And the regulations, is important that there are general applicability, they are legally binding, they are applicable in the same way in all of the EU member states and enter into force at the moment of publications. Also, the directives enter into force in the moment of publication, but they address member states. There are principles and not rules. Therefore, states are obliged to achieve the principles and goals that are stated in the directive within the time limit that is stated in the directive. The decision addresses a member state or a natural legal person. It is binding into its entirety and it enters into force upon notification. Now, in this slide, I have tried to make it as easy as possible, these 5 secondary EU sources, by dividing them if they are general or specific, and if they are binding and not legally binding. So the regulation, they are specific, and binding, rather the directive, give general goals and are binding. The decision are specific and binding, while the recommendation are general but can also be specific but are not legally binding, and the same is regarding the opinion. The soft law, in the case of the EU, we have pre-law, post-law, or power law, but the goal of them is to make it possible in the near future to have a regulation or a directive. So regarding the regulation between EU law and national law, there is a supremacy of the EU law, there is a direct applicability and direct effectiveness of the EU law. There is an interpretation of the national law in coherence with the EU law. Although national states might have a monis or dualist system, these are things that are directly applicable. Also, in the case of Germany, with several steps, it has been achieved that the EU law have supremacy compared to the national law. However, they should not infringe the basic principle of the German basic law. So, as I stated, the EU is a sui generis organization that have several similarities with the concept of federation. Within the EU, it is really fundamental the concept of sovereignty. In addition, in the EU law shall be coherent with the basic EU law which are codified in TFEU and TEU. Thank you for listening to me, and I hope that you will join us on the next video.